Members of the jury. That's all right, I'm only kidding. It's a very long time since I addressed a jury from the point of view of an advocate. I may never do it again, and I shouldn't imitate such a difficult art now. Nevertheless, this closing lecture has something of the summing up of a barrister of the evidence that's gone before. In my case, 23 lectures given over 4 years. And I suppose I ought to obey some of the rules of the advocate. Like, for example, I shouldn't express over-strong views on controversial subjects. And so I will say absolutely nothing about the complete lunacy of leaving the European Union, especially were it to be based on the absurd proposition that somehow the English law wouldn't benefit from sharing its ideas of law with lawyers and judges of other equally civilized countries that happen to be the other side of the channel. So I will say nothing more, well, not much more, about that. Different from summing up, I suppose, is that in this lecture I should express thanks. I'll have to do it fairly shortly for want of time, but that will not diminish the sincerity of the thanks I express. That didn't seem to work very well. There we are. And here's the first person to whom I should express thanks, Thomas Gresham, 1518 to 1579. England's wealthiest man. There he was in Antwerp, fixing the exchange rate of the pound, eliminating the royal debt of his then king. And we'll find out from the official biography being published, being written of him at the moment, which side of the libel scandal he might have fallen on. But we are, of course, indebted to him, all those of us who are given 6 soapboxes a year and up to 4 years of 6 soapboxes to stand on. Without him, this would not be possible. There you see him, a couple of poses. I think that's the right coat of arms, and there's the motto, "Thy will be done." The modern incarnation of Gresham is, of course, the provost, to whom I'll turn in just a second, but he says he's not the richest man in Europe. Well, there we are. But of course, Valerie Shrimplin, the academic registrar, and her staff, James Franklin, Dawn Fawkes, Alexander Mee, until such time as he felt it necessary to go to the Tower of London, Richard Taverner, Tino Georgiev, and Georgina Culver. And it is important to say that as a team, they are unfailingly courteous, helpful, encouraging, and positive, not just to me, but to all the others, many who they have to deal with who fill this role. And I have imposed on them by presenting lecture notes far too long and far too late, ludicrously oversized PowerPoints. I've made them put on a lecture from a hotel bedroom in Jerusalem, but they were never so tested as in the Israel-Gaza lecture, which I gave with others. And unhappily, there was something of the nature of a concerted, I suppose the word has to be attack on us, because the staff were subject to unpleasantness even before I'd opened my mouth, and it continued thereafter. It was a great sadness that that happened. The staff dealt with it perfectly. I'll come back to that in a second. But it was a sadness because here was an opportunity for a really important point to be considered. The important point that was to be considered was how we, the ordinary public, decide whether war crimes are committed by parties to conflict. It was an issue that was easily capable of being identified and explored, but sadly the agenda was, as it were, taken and a straw man was put up, perhaps, in order that it might be put down. And the lecture, or the discussion that was to follow it, could have been important not just for dealing with that very important topic, but for the associated topics, not just related to Israel-Gaza, but to all many other conflicts around the world, which is, are they ever subject on either side to the rule of law? And more important almost than that, how can we, the voting public, who put in the politicians who deal with these really grave problems ever have enough information to make the important decisions that lecture was aimed at facilitating or approaching at any event. I'd like to say thanks to both provosts, Sir Roderick Flood, who was good enough to appoint me knowing how wayward I would be, and then to Sir Richard Evans, who, along with Valerie, fielded the difficulties that this particular lecture generated and elegantly held the balance between preserving freedom of speech and preserving the right of others to hold and to express an opinion. It was done with ultimate good manners and complete, in the long run, complete effect. But the losers, I'm afraid, may have been us, the audience, who were deprived of the advantage of a fuller discussion than in the event we had. So thank you, Provost, for that and for your kind words of introduction. There are, I think, and this is a warning to you, different types of lawyers. Throughout the last 4 years, you may have detected in me the odd sign of skepticism from time to time about the law in this country and about the law around the world. But remember, in our country, there are many lawyers, particularly in the criminal field, who day in, day out take society as it is. They're not worried like I am about why people commit crimes. They deal with the business of crimes being committed in a society regulated by law, and they do it not only well, they can do it absolutely brilliantly, without having the angst that I have. And then there's another cadre of lawyers, absolutely brilliant, intellectual, informed, who go on to become the senior judges. And again, they may not have those sorts of skepticisms that have peppered my lectures. And they do a phenomenal job in conserving and also in developing the law by which we are run. So be careful about the way I have approached things, because I may simply be completely wrong, and you should disregard everything that I've ever said. Because in this country, we tend to see the law and lawyers as for the good. I'll come back to that in the quotation of someone else much later, for it contains a hidden risk. But if you look back on our statute law, whether it's on slavery or against slavery, on enlargement of the reform, of the electorate, on divorce, on abortion, or that's always going to remain controversial, on abolition of the death penalty, and indeed on human rights, the law of this country has progressed in a way that society has found ultimately comfortable and positive. And it's not just the statute law, it's the judge-made law. Many of you will know of Denning, although he may have somewhat diminished in stature if you read about how he dealt with the Profumo affair. The rest of the time, his judgments in the Court of Appeal and for a short time in the House of Lords were sometimes provocative, but advancing of the law. And we have in our country the opportunity in our judges to make the law, and it's just worth bearing in mind that, because it's a really positive feature of our law at a time when others are trying to say that we shouldn't share our law with others. Well, we do. And here's something that happened in a case called R&R as recently as 1990, when for the first time it was made clear that a man can rape his wife. And the law was made not by the statute, but by the judges. And here's Lord Keith explaining how that happens. The common law, he says, is capable of evolving in the light of changing social, economic, and cultural developments. And we have that great advantage in our senior judges. He refers to the proposition attributed there to the man Hale long, long time ago. Proposition involves that by marriage, a wife gives her irrevocable consent to sexual intercourse with her husband under all circumstances. In modern times, any reasonable person must regard that conception as quite unacceptable. So this is an example of the flexibility of our law, not just by statute, but by the judges. All things very positive. New law is usually about change. And I'm going to take you to a couple of examples of change that relate to law and the legal society in which, or the legal part of society in which we live, in a minute. But first of all, by way of diversion, digression, and with a purpose, let me tell you an anecdote, in fact two, about that perfectly dreadful judge I referred to at an earlier lecture, who made an outrageous, improper observation at a conference where sentencing was being considered, saying that his syndicate had, in respect of a rapist at Cambridge, given the defendant a half blue. And the terrible, terrible observation was repeated by a recently retired, at that time, a few decades ago, Lord Chief Justice. Terrible judge. Things are different. Such shockers no longer with us. But let me tell you two stories about that same judge who gave the original terrible point to the sentencing conference. The first is a case I was in as a young barrister, led by my previous pupil master, prosecuting an affray of, I think, 9 or 11 young men from Wisbech in the Fenlands. The affray was being tried by this wretched judge in Norwich, and all the barristers were expecting a couple of weeks in a hotel with jolly evenings. Michael Lewis, my pupil master, great chap, sadly no longer with us, not a slouch, opened the case to the judge and jury. It was lunchtime. The judge dismissed the jury. He didn't dismiss them in the words of another judge, who apparently was heard to have said once at the lunch adjournment, members of the jury will now rise for luncheon and you can go and have your dinners. Well, he didn't say that, but he sent the jury home, and he then looked over his desk, this wretched judge, and he looked at defense counsel and he said, now you've all heard the facts and you all know the law on affray. We'll sit again at 2. Well, everybody knew what was involved. The pressure was on. Michael Lewis sent a message through the judge's clerk saying, you can't do that to the judge. You've got to give them something. You've got to offer them a reduced sentence. The message came back through the judge's clerk, but I'll voice it in the judge. I'll nail them to the floor. 2:00, all bar 2 of the defendants pleaded guilty. The other 2 were represented at the end of the trial, one by a rather mild-mannered advocate who said something, and I've forgotten what it was, in the course of his defense of his client, which allowed the judge to ridicule him mercilessly in the judge's summing up, so that the jury acquitted his client, and the judge, actually, to be fair to him, found that amusing. The next case was not one of mine, it was a colleague of mine, also sadly dead, called St. John Williams, who was representing a chap who'd injured his hand, maybe lost part of it, in a machine at work. And so the employers were on trial, civil case for damages. And in the course of his evidence, the plaintiff, as they were then called, claimant now, gave answers roughly along the following line. You're quite right, the machine was unguarded at the time. Oh, well, you're quite right, it should have been guarded. Oh, you're quite right. It was I who opened the machine, and yes, I did put my hand in when I knew I shouldn't have done. Lunchtime, the judge summoned everyone to his chambers. St. John Williams, he said. Yeah, yes, Judge. I shan't be finding for your client. No, Judge. He turned to counsel, let's call him Smith, appearing for the employers, but of course he wasn't appearing for the employers, he was instructed by an insurance company. I don't know which it was. Let's assume it was the Prudential. Smith? Yes, Judge. Who are the insurers? Prudential. Very well. Tell the Prudential this is the first honest Irishman I've heard in a very long time. We'll meet again at 2. And at 2:00, although they knew they were going to win, the Prudential had settled the case and given some money to a man that the judge liked. Everything that that judge did was wrong. Putting pressure on people to plead guilty, threatening the defendants with long sentences, humiliating counsel in his summing up, forcing the prudential, or whoever it was, to give money in order to curry favour with him in respect of somebody he clearly liked. And above all, characterising a whole nation by whether they were honest or dishonest. But as you look back, do you detect anything of justice in what this wretched judge did? Is it a question of the passage of time and standards changing, and that we have to be careful about looking back too much in the way that we are, for example, with the sexual cases, as I explained in the last lecture, but one with today's standards at yesterday's behaviour? The judge, incidentally, famously or infamously, lived in a house called Truncheon's. And he never made it to the Court of Appeal, and in retirement could be seen sitting in the public gallery of the Lewis Crown Court, listening to modest cases he was no longer able, despite his enthusiasm, to be involved in. But now to the two bits of retrospection that we should consider. The first is Hillsborough. 27 years. For one narrative to change completely to the other. For, at the moment, all blame being allocated to the police. But the truth, and of course we know that Lord Taylor got most of the way in his first inquiry to the correct answer. But we know that lawyers, civil servants, and all sorts of people of great skill involved in the overall justice process were involved, and it took 27 years to put it right. The question I'm going to ask you, I'll ask you after the next matter, which is a case called Jogee, which was, I think that's the pronunciation, but I don't know. It was decided by the Supreme Court, our top court, in February of this year. I hope they haven't got a machine up there with a fence on it, or a gap that they shouldn't fall down. Never mind. The Jogee case. The Jogee case involved the criminal law of joint enterprise in relation to murder. And the courts had held for a very long time that if you were involved in a criminal act, a general concerted criminal act, with one particular intention, but not an intention to do a very serious crime, but you foresaw that one of your number did have that particular intention, for example, to go and kill, then although you didn't have that particular intention, you were just engaged on something else, beating people up, for example, but not hoping to cause them serious harm or to kill them. The fact that you foresaw that this other chap had that intention could make you guilty of murder itself and liable to life in prison. Well, the Supreme Court decided that this was wrong. They overturned it, they changed the law. But they changed it, if you read the summary judgment, in a very gentle way on everybody except counsel. They asked counsel to justify it, but counsel couldn't. But of course, why had the law gone wrong? Well, in the London Review of Books, one of the counsel involved in the case has written an article. She was for a party, I think, that was intervening, taking part in the hearing. And she explained the history a little bit more fulsomely. The case, which had given the wrong law, happened as long ago as 1984, 2004, 32 years. And here, the law made its wrong turn, she explains in her article. Sir Robin Cook, a senior judge from New Zealand, later given a peerage and sat as a judge in the House of Lords, had not grasped that although foresight might be evidence of intention, it was never previously been treated as a substitute for intention and should not be confused with it. She went on, in its judgment, the court declared that there does not appear to have been any objective evidence that the law prior to Chan Wing Siew, that's the 1984 case, failed to provide the public with adequate protection. And further, she said this: speaking of the Supreme Court. Judges are masters of diplomatic language. Criticism tends to be muted, but is no less powerful for that. When a judge calls an argument bold or novel, they really mean it's barking mad. So when the Supreme Court bluntly says Chang Wing-Soo was an error, and the correction of error brings the common law back into the recognition of the difference between foresight and intention, the gloves are off. Cook screwed it up. It means the doctrine of precedent cemented the error into law until now. Well, why do I bring these two examples, both really reaching fruition this year, to your attention, and given my generally skeptical approach? How do you, the citizen, value your overall legal system? Are you satisfied with it because it ultimately gets things right? Or are you disappointed with it because it can let things be wrong for so many years? And when you hear our system, I don't have an answer to that question. But I recognize, and you'll see again in the words of another judge later on, some reflection of this as an issue and as a problem, perhaps. It does seem to me it's a question that should be asked, especially when our system is so regularly praised to the limits as the greatest in the world. Let me turn then from those few observations about the law itself with one other comment before I part. If you feel that we are secure in our legal system because nothing has gone too terribly wrong for quite a long time, turn to the Provost's volume, The Third Reich in Power, and read all the index references to law and lawyers and see what can happen in civilized countries when extremes take hold, including of the legal system, and you will not sleep as comfortably at night. It is truly a pretty horrifying tale. And one of the things that we have to be concerned about, as people say, rip up the European Convention on Human Rights, one thing we have to be concerned about is that however safe we may seem, having another level of supervision and another level of court system to which we can turn may, in uncertain times, be something of very great value. A few words now then about advocacy, I suppose, and judges. But first, let me mention a third category of lawyers. We had the professionals, we had the high intellectuals. And the third category of lawyers, a little thought of these days, and they are the radical lawyers. They first became apparent, I suppose, in about the 1970s. They drifted away from mainstream sets of chambers. They did astonishing things like only defend, or bring cases against the police, or represent the IRA. And my goodness, the rest of us, and I'm afraid to say I have to be a part of that, embraced warmly by the wonderful establishment system to which we'd all succumb from whichever social background we originated, would perhaps look down at them. Judges would barely be able to speak to some of them or of some of them. But they carried on. Some of them got quite big names. Some of them may even have liked a bit of fame. It did them no harm, and there's nothing wrong in that. So that, for example, many of you will know the name Michael Mansfield. Perhaps less of you will know, but should know, the name Ed Fitzgerald. These are people who've done a great deal, and there are many others, by being prepared to become radical lawyers. And I suspect when people look back, they will be seen to have been a great value for our society. Not because they stayed off there in some silo of speciality, but because actually England, in its usual subtle way, moved towards them, recognizing that it was necessary to do so. And more lawyers who would originally have found it unpalatable to represent the IRA or to attack the government or to attack the police found that work that they would not only be willing to do but be enthusiastic to do. And by the existence of this, at one time people would have said, extreme group of lawyers, the lawyers have, I think, become more fitting or fitted generally for the society they serve. So those lawyers had, I suppose you could say, a form of courage. And indeed, I was going to say something, and will say something, not very much, about the courage that you need to be a lawyer, because you do need some. But then you need courage to be many jobs in any professions. The school teacher, putting his or her toe into the water aged 18, does she or he know whether they're going to have the courage to face 30 teenagers intent on destroying them in the course of a lesson? They don't know it, and they might fail. Does the surgeon who deals with life-risking work in his or her field know whether they will have the ability, not just the technical ability, but the ability to deal with the huge ethical problems that may come their way? And of course, the best example of all is that those in the military, whether ratings or privates or officers entering, do they know whether they're going to have the courage that may ultimately be required of them? And so it is with the law. When you go into the law, you don't know whether you're going to have the courage that's going to be demanded of you to represent your client in advocacy or to face a difficult judge or a difficult court. And it's worth bearing in mind that, as with all professions, there are heavy and sometimes very heavy psychological demands made on lawyers, to which they sometimes all too tragically succumb. But let me just say one other thing about advocacy. Advocacy is not simply presenting an argument so that you can address the argument. It's different from that. And if you read Cicero, sometimes thought to be the greatest advocate, where he puts so much of himself and draws so much out from his audience, who he engages and involves in the process of advocacy, you realize that advocacy is actually an exercise of power and leadership, often by the advocate. Before we come to see a modern reflection of that reality, I'll just tell you another little story, which perhaps makes the point. I was instructed, again, quite junior, and led by a very eminent QC, to oppose the gaming license of somebody who owned a very smart club in Mayfair, Claremont, something like that, I think. He'd been playing at his own table, so he lost his license. And this was on appeal, where we went to the Crown Court, and you had a judge and about 4 or something magistrates sitting with him. We gave our evidence first. He was finished. And it was lunchtime again. And so we adjourned to the scruffy mess in a London Crown Court, and the applicant, who was going to give evidence in the afternoon, who we were going to poleaxe with the material we had against him, was affability itself, walking around the tables, speaking to us, generally being as charming as he was. He's a brilliant advocate called Robin Simpson, and I think he's still with us. So we assembled at 2:00, waiting for the gaming man who owned this club to be called. And Robin Simpson stood up and said, "I'm not calling my client. And if I'm wrong, blame me." And he then gave an absolute tour de force, saying all sorts of things which weren't really quite right for a lawyer to say, but it didn't matter, as we sat there gnashing our teeth at having pulled our punches in the morning. And sure enough, he got his license back. A few weeks later, I met one of the justices, who I happened to know. He was a guard on the underground trains when they had guards, and I knew him at the local Labour Party group. And I said to him, "What on earth were you doing? Didn't you realize you were being fooled and bamboozled?" He said, "Yes, of course we realized we were being fooled, bamboozled." I said, "Well, why did you do it?" He said, "We just didn't have the choice. We had to do it." Advocacy can be that powerful. to make people do that which they know is not necessarily right if you simply wrote it down. And advocates have that power and that responsibility. So let's turn to what the present presiding leading judge of the Supreme Court has to say about this, because he makes the point on the Supreme Court website that judges give a lot of speeches these days, much more open. The Supreme Court is much more user-friendly. So he expresses opinions on quite a lot of things. And here he deals with oral argument. He says, being a supporter of it, he says, "It's not entirely clear to me quite why oral argument is of such benefit, given that we so often have first-class written arguments. But it clearly must have something to do with the way the mind works, the human mind, not just the judicial mind." And in his own measured way, he's reflecting, I think, the reality that Cicero demonstrates and that Robin Simpson demonstrated in the case I've told you about. But his other observations about litigants and advocates may be of some interest to you. He said, this is all this year, "Exclusive rights to represent litigants in court. They are accorded a status in society, and at least in some fields of law, they have the opportunity to earn quite large sums of money. And there is a reason for this. The reason that independent advocates have privileges is because of the fundamental importance of having independent advocates in a modern, civilized, democratic society, and above all, a society run in accordance with the rule of law." And then said this, "It's naive to expect many able young people to become barristers if the financial rewards are paltry. Although I must add, expressing my great admiration, that a few of the most able young people are socially committed enough to enter the less well-paid areas of the law. But human nature being what it is, the most sought-after jobs at the bar and elsewhere in the law are inevitably at the higher-paid end. In a genuinely proportionate way," he says, "costs are commensurate with the amount of the issues at stake as the ultimate aim, and it is one to which everyone, not least advocates, must strive." I wonder if that isn't a little overgenerous to the lawyers who find money the most important stimulus. I don't find it an entirely happy passage to read. He also said this, "Shortage of money confronts the rule of law in general and access to legal advice and representation, hence the legal profession in particular. And in the long run, it could risk undermining public confidence in the rule of law. In some countries, such as the UK," he says, and this is the passage to which I was referring earlier, one of them. In the UK, he says, "This is a difficult issue in which to excite much interest, because due to our fortunate history, we tend to take the rule of law for granted, and we blithely ignore threats of the breakdown of the rule of law." He then says, the adage is the price of liberty and the price of the rule of law is eternal vigilance, and all it takes for evil to triumph is for good people to do nothing. In other words, the complacency engendered by decades of internal peace and democratic government endangers the rule of law. And it was that warning, really, that I asked you to have in mind, not when you answer, but when you ask yourself the question. For example, about Hillsborough and things like that. Have we, in fact, been living with some complacency, and will we say, oh, well, it was put right in the end, forget it? Or should we be more vigilant in checking whether, in our long period of peace, our legal system nevertheless needs to be more carefully checked, calibrated, stress-tested, whatever you like? So, although I might differ in some respects and agree in some respects with what Lord Neuberger says, I do find it difficult to regard the huge sums of money that some lawyers earn as justifiable, even in societies with the divergence of wealth that we are now encountering and that is getting bigger. For commercial cases, the level of earnings by the merchants encourages and sometimes invites, indeed, very substantial payments to laws, and on these issues I remain a bit unreconstructed, not least because I find too much talk about or thought about money unhealthy and perhaps even slightly demeaning. and remain suspicious of any well-intentioned task being over-rewarded. And I'm probably wrong in that. For most of my professional life, I've earned comparatively little. In the last few years, when rates have risen, I have, I hope, moderated the total bill by application of the multiplier. And, of course, it's always possible for lawyers to do a lot of work pro bono. The difficulty I have about this conception of lawyers earning, or this reality of lawyers earning a very great deal of money, is similar to the one I have for dodgy potentates who prefer to die after decades of being presidents here or there with huge wealth corruptly harvested with the absolute certainty that their reputations will be openly trashed once they are dead. Few reputations of long-serving presidents of Africa or elsewhere survive long, and some leaders, Tony Blair, and one of the presidents, Clinton, contrive a measure of reputational self-destruction in their own lifetime. But then I can't quite understand how a 4-story yacht might be worth the stripping of a knighthood and public disgrace, should that ever happen. And of course, as you will know from an earlier lecture, I suffered the attempts at destruction on me by the Privy Council, including by Lord Neuberger. And the case is dealt with in that earlier lecture, and I returned to it only really for a couple of reasons now, one of which is a very recent reason, of which I became aware only a couple of weeks ago. But for those of you who weren't at that lecture, you'll remember that I was presiding over a case where perhaps the expectation was that I'd rubber stamp the way that that particular island, Jersey, conducted itself, when in fact it did quite a lot of washing of money, as I suppose one would now more readily understand and accept. And for some reason or other, I was abandoned by everyone in the Privy Council until such time as a lawyer who was present in court had the integrity and courage to tell the judges quite how wrong they were, so that they made a grudging admission and matters were, to some degree, put right. But why it becomes interesting is, for me, in two ways, apart from the fact that, of course, it needed both fortitude and the support of friends to face an implacable and over-powerful foe, as these judges had become. And without friends and family, you wouldn't be able to do it, I don't think. At least I wouldn't have been able to. And by the way, I wrote extensively to the judges trying to get them to engage with me, but they wouldn't. They always had a procedural reason for not doing so. And so one day, I think, perhaps soon, I'll publish the entire correspondence on the website of the foundation that's in my name, and then people can pick over it themselves, and they can listen to the tape recordings that show the truth. But enough of that. In the course of this long escapade with, with Lord Phillips, he was the presiding judge, he ended the correspondence eventually by saying, "I've said as much as I'm going to say about this case." A friend of mine who's present here today said, "Well, that's interesting, because he hasn't said anything to you." And indeed he hadn't. Just a way of shutting it down. But never mind. In the course of the correspondence, I wrote to him a letter that included the following passages. This was in August 2012. It went to Lord Phillips, but it was copied to all the other judges. That's Baroness Hale, Lord Brown, and Lord Neuberger, and one other who's now dead. And I said to him, well, maybe the senior appellate courts should sit with assessors, lay or legally qualified, who could bring more ordinary experience to bear during hearings, although they taking no part in the judgments. In this case, I said, that's the case I was sitting as a judge in, it's hard to imagine a magistrate or a GP or a school teacher or a circuit judge sitting with the board, not asking why on earth the judge's position was not being protected. And I said, and they would probably have seen through the other features of the hearing and of the conduct of counsel, Miss Fogarty, she was the woman who had written to the Supreme Court justices and explained the folly of their ways. I and many others have thought obvious, and that should have been put before, should have put the board, that's the Privy Council board, on its guard. Failure of counsel to intervene, failure to expose George's culture in full, council having a vested interest in disposing of a new commissioner, clearly willing, that's me, to reflect his and the jurat's concerns about the island's culture. Clear indication by me that they should acquit the man it was being said I was trying to pot or have convicted. And then I finished in this way. In criminal courts, juries these days are confident enough to ask questions, even when discouraged by the judge in accordance with modern judicial training. Jury questions not infrequently pick up points of importance missed by counsel or ask questions revealing of truth that counsel for tactical or strategic reasons prefer not to ask. Any appellate court that allowed its proceedings to be democratized by the inclusion of a lay or junior judicial element might, to its surprise, find itself in a vanguard of procedural developments that would be adopted enthusiastically elsewhere. The other day, I was in the Inner Temple, sitting at the table where there are senior barristers and judges. Sometimes I sit there, sometimes I keep quiet elsewhere. And the chap on my right, who's not at all a sort of heavy conservative or reactionary, he said, "Do you know," he said, "Lord Neuberger has suggested that ordinary people should take part in the senior courts of this land." Well, you can imagine I suddenly became rather excited, wondering if my letter had done the trick. It took me some time to find the speech, but although it was this year and it was in Edinburgh, and I fear that the chap who was speaking to me, and who was reflected by others who'd been similarly concerned at this extravagant notion, I think they slightly overstated it. Pity, really, but nevertheless, I haven't got time for that or that. This is what Lord Neuberger actually said, and just read it. He said, "We each have a system," he's talking of judges, the two groups, judges and lawyers, that's advocates for the most part, understand each other. A late entry judiciary consisting mostly of people who've been practicing lawyers is a great advantage. It means that our judges have experience and understanding of the other side of the courtroom, with all the pressures of legal practice. And it also means that our judges have some direct experience and understanding of the real world, if there is such a thing, outside the courtroom. Not to say, he said, that I am against recruiting judges from other areas, such as academia or government. On the contrary, I think that limiting judicial recruitment at any level to former practitioners is positively to be discouraged. Diversity is always an important aim, and I think this is the line that worried conservatives sitting with the judges and the senior practitioners, and it should not be limited to the familiar categories such as ethnic origin and gender. Diversity in social, education, and professional backgrounds is every bit as vital. So he's opening the door to a much wider pool from which the senior judiciary may indeed be called, but I think if you read on, he's still restricting it to lawyers, even if it's lawyers working in government or lawyers working in business, because he says, "Nor would I rule out any element of early entry judicial career structure. Not only would it add to diversity of judicial background, but it may improve diversity by attracting those who might otherwise drift away from the world of law." So I think he was talking about lawyers. But it's an encouraging move, in my view, towards, and whatever he did to me, everybody seems to think Neuberger's a nice bloke, and so let's assume he is. He's very open if you read what he says on the Supreme Court website. And if there's going to be an introduction of, if not yet lay people, but a broader people from a broader spectrum of the legal society into the decision-making of the higher courts of our land, that can be no bad thing, and I would have thought must be a good thing. But it's part of the business, I hope, of the democratization of our law, which you, the citizen, can take part in. Before I close, I have two bits of updating to do for you with a purpose from the Yugoslav court. And again, they're two decisions of this year. And they tell us something about those courts, and they tell us something perhaps about our own legal system. The first decision was Radovan Karadzic, the leader of the Bosnian Serbs, tried for, I can't remember, it's 6 or 7 years, eventually convicted of lots of crimes, including genocide, and sentenced to 40 years imprisonment. The court was presided over by Judge Ogon Kwon, who I knew from his time on the Milosevic case. He's an absolutely terrific bloke, full of integrity, intelligence, learning, knowledge. You couldn't have a better judge. But in the sentencing part of the summary judgment that you can read on the readily accessible ICTY website, the court said this. Hang on, I haven't got it. No, they didn't. I'll have to read it to you. Never mind. I thought I put it up, and I obviously hadn't. But what he said in the judgment was this. They said that in mitigation, Karadzic had presented evidence that he'd entered into an agreement with the American envoy Richard Holbrooke in July 1996, whereby he resigned from public and party office and withdrew from public life with the understanding that he would not be prosecuted at the tribunal. And the judges went on to say the chamber, they didn't express a view on whether there'd been any such dirty and incomprehensible deal, but they went on to say, the chamber considers that regardless of the reason or reasons behind his decision, the accused's decision to resign from public and party offices in July 1996 is a mitigating factor. Here's a man who's committed genocide of 5,000 people, or at least been involved in it, 5,000, and many other crimes. He's been the leader. After his meeting with Holbrooke, he went into hiding for 10 years, never said sorry on his own behalf, didn't plead guilty, and fought the trial. What mitigation is that? And all of us listening to this judgment, and I was over in The Hague when it happened, for a reason to which I'll come, could count up on our fingers before they'd left the bench that 40 years meant that Karadzic may, with remission, depends where he served his sentence, may return to freedom if he lives to 90, not by any means unreasonable as a prospect. The judges got it completely wrong. Why? We don't know. That day I was speaking before the hearing with some real victims of the crimes committed against Bosniak Muslim women in Bosnia. And they were looking, of course, for a life sentence as part, at any event, one component of something that may have resolved for them the impossible experiences they had had. And 40 years didn't work for them. They left The Hague yet again disappointed. And yet again, the point I've made and tried to make repeatedly in these lectures, victims actually seem to come pretty low down. Maybe poor Judge Kwon was in a court where there was a lot of horse trading and sentencing, just as there was, I think, at Nuremberg. But that's no excuse. In the same way as our systems of court, whether it's for Hillsborough, whether it's for joint enterprise, have to work in a way that's satisfactory to the public, the courts operating in respect of the former Yugoslavia should not work in a way that is ultimately so disappointing to the victims. The other case, and I haven't got the passages copied up for you, but it doesn't matter, I'll read them to you, was a quite extraordinary case called Šešelj, about a man called Vojislav Šešelj, who was the propagandist and who said the most terrible things and was charged with inciting crimes and all sorts of other involvement in grave crimes. His trial, I think, lasted 10 years. At the end of it, the judgment was pronounced, and the composition of the court was Judge Antonetti in the chair, a Frenchman. The next judge hadn't heard a word of the evidence because the second judge had to be removed from the court when he wrote a letter to 60 of his best friends saying that he'd been under pressure to bring in improper verdicts, not by the presiding judge of this trial chamber, but by the presiding judge of the court in general, so he'd had to go. And this other judge had read himself into the case. He may have looked at things on video, I simply don't know. And his statement to explain what his part in all this is yet to be published on the site. But the third judge, I think Italian but writing in French, Lattanzi, said, amongst other things, the following. The majority's decision, speaking of the majority who found, I should have said that, the majority acquitted Sheshel of everything. Lattanzi would have convicted him. And she said, the prosecuting majority's reasoning does not include the totality of the evidence. It focuses knowingly on sparse defense evidence. The majority are forced to consider displacement in buses of non-Serbs as humanitarian aid. She said the majority didn't follow the applicable law. She spoke of the terrible things that, on the evidence, Sheshel was said to have said about Bosnian Muslims by terms equivalent to excrement. And she said, I hold that the use of those terms, together with his constant references to genocide committed by the Croats during World War II, and the saying of an eye and a tooth for a tooth, shows that he took the risk of murder. But finally, she says this, and this is something I have never heard said or seen said in any other court. In the penultimate paragraph, she says of the majority sets aside all rules of international humanitarian law that existed before the creation of the tribunal and all the applicable law established since the inception of the tribunal in order to acquit this man. And finally, she says, I felt I was thrown back to a time in human history centuries ago when one said, and it was the Romans who used to say this to justify their bloody conquests and murders of their political opponents in civil wars, and then in Latin, but in English, in time of war, the laws fall silent. How can a court system, even a new one that's having teething troubles, pretend to the outside world, and in particular to victims and those interested as human beings, that it is functioning properly when after 10 years it can produce the equivalent of a one-all draw with the judges at each other's throats, as they must have been to produce these judgments in conflict. And you can see some parallels of the difficulties that legal systems suffer. One, ours, of course, subject to the manners that the woman advocate in the case referred to in the article in the London Review of Books. The others completely with the gloves off. And how are the interests of victims honoured by a court publicly this much in internal conflict? What will victims think of a court that after 10 years fails to reach any conclusion of coherence? Although a new court is entitled to understanding when justice processes are regarded as systems, are there indeed similarities of the kind shown here and the uncertainty of the 20 years of the Hillsborough blunders? And must we forever be alert to the shortcomings of legal systems, rather as Lord Neuberger, in that passage I read, pointed out? Well, ladies and gentlemen, in digging out material for these last 23 lectures, I found odd things. And early on I found a quotation that I liked very much. Some people tell me that I'm completely wrong, but I'm going to show it to you in any event. Because I think that it in some ways reflects both how as individuals, with or without religious belief, we should approach each other as neighbours, and maybe that can be part of my interest or reflects part of my interest in how you stop people doing the terrible things that bring them to court, rather than concentrate on nailing them to the floor, or whatever judges sometimes do. And here it is, and I've twinned it with another quotation. Charles Darwin, in The Descent of Man, said, As man advances in civilization and small tribes are united into larger communities, the simplest reason would tell each individual that he ought to extend his social instincts and sympathies to all members of the same nation, though personally unknown to him. That, it seems to me, is a prescription for how to live and how to approach one's neighbour that is hard to beat. The next sentence, I did say I'd come back to Brexit, may just have a topical touch. This point once reached, there is only an artificial barrier to prevent his sympathies extending to men of all nations and races, for example, across the English Channel. Which is one of the two reasons why I have quoted Nigel Farage as the alternative view, and to ensure that there is balance, saying, as he does, perhaps our own position to even the level of European integration we now have, let alone any more, is well known. The next slide, I'm afraid, will possibly remind some of you of the picture quiz on Have I Got News for You? And it's the second reason why I thought to twin these two comments in my second to last observations to you, and I'm nearly out of time. But I will finish. Down, the village of Down in Kent, has provided homes to Charles Darwin and to Nigel Farage. And there you see on the top left, Charles Darwin's house, and on the top right, Charles Darwin's study. And on the bottom left, Nigel Farage's house. And he's a good-natured bloke. I'm sure he won't mind the picture I put beside it, whether it's his study or not. It's the village pub. Finally, let me end this with confession of an act of complete vanity. I shall be 2 minutes. With an act of complete vanity, folly, you may say. But to a purpose and not just to seek your sympathy. The College of Heralds did one of these at my request. They don't come unasked for, to reflect all those aspects of family or history or whatever it is. There it is. It's only going to be a single generational thing in my case, because I have 3 daughters. I think they're shown there by the 3 torches. And heraldry doesn't really acknowledge women. It only acknowledges everything passing through the male line. But let's forget that act of vanity. I had, therefore, to think of a motto. Now, mottos on coats of arms are aspirational. They don't reflect what you've actually done. So I puzzled over what my motto should be. And I thought not what the law would want, some observation about justice, but what the family from which I'd come, both before me and surrounding me, the family into which I'd married, and the friends that I had, and their values. And it seems to me that I hit upon, I hope I did, a motto that has something to say about the law, or the way lawyers may serve their fellow men, that I may place others' causes before my own. And as I thought about whether I should show this to you, I thought, as a matter of interest, does this in some slight way follow on from Thomas Gresham? His motto looked to the will of a divinity, of God. But we are in a secular age. And if this aspiration, and it is no more than that in my case, honoured more in the breach than in the reality, has any value, is it a value that can be seen as at least consistent with the values of Thomas Gresham, to whom we are indeed all indebted. Thank you very much.